you're asking for is crossed, then I think you have a right to do that if he decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up, and he either takes her answer or he doesn't, and that's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
What's good, y'all? Let me know. Make sure y'all can let me know y'all can hear everything. Everything's smooth. Right now, who we got on the stand is the divorce attorney for Nathan
At this
Wade.
point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes, so you can proceed.
The discrepancy currently, just like it was yesterday, is whether or not there is attorney-client privilege in his divorce case.
If you say so. I mean, I don't.
You have your text if you need to refresh your memory. September 18th at 3:11 p.m. You need to.
Y'all say what's up as y'all come on in. Make sure y'all let me know y'all can hear everything. Everything's smooth.
Asking you if you knew who I could get an affidavit from about the affair, and you responded no. No one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell knew, correct?
He seemed like he about to fuck something up, though. He seemed like he about to fuck something up.
Under oath, he would testify.
I'm going to object to the source of the witness's information about that, whether that's firsthand information or not. And Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
I'm just, it's been objected that I'm not asking about all the texts and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what
this shit about to get drawn out like I'm a
information that he's providing is. And so that is, I'm struggling,
sure.
And I know everybody else.
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is under those grounds, then you being able to match them up word for word, I don't see that as being the necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if
as y'all come in, make sure you hit the like button.
That's great.
Say what's up in the chat.
I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with the business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
Yeah, I feel like, dude, even from yesterday, like this has been the worst part of this whole thing. Cause he come off as like somebody who knows something that they shouldn't know, or he just trying to make sure he don't say nothing to fuck something up. Cause look how long it's taking. This ain't a good look. Look how long it's taking him to answer this shit.
So what I have is a text message from you saying, "Oh my God, Nathan took Fani on a trip to Napa and paid for it with his firm."
Continue reading.
And you said, "Is he that dumb?"
Mm-hmm.
And I said, "Wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
That I will call you as soon as I land, and wow?
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
What was you doing talking to the ops? And now you're here talking about attorney-client privilege?
Okay, so,
This supposed to be
I don't
his
have that,
man's too.
and I can show my phone.
This supposed to
But
be
I
his
don't have that in my
man's,
phone.
y'all.
So the question is just, do you recall
I do
This
not
is
recall.
nigga.
communicating
This
that?
nigga
do not
divorce
recall.
attorney. He up there
Recall telling
talking
me
to
that it
Ashley
was
Merchant.
when, she had to move her daughter a trip to California.
I do
This
not
is
recall
wild.
that.
And Judge, may I approach the witness?
You may.
Thank you. In the pack that you.
Oh, I see it.
Boy, we may have just found the weakest link. We may have just found the weakest link. This man
Yes, I see
divorce
this.
attorney, and he
Does that
gossiping
look
with
like, is there a
the
pressure memory?
with the opposition. That's wild to me.
It does not. I mean, I see what's on the text chain, but
That is wild.
you said this happened January 5th?
I can tell you exactly when it happened. Because there's no date and time stamp on that. Let's see.
Oh boy, how you got your divorce attorney, which was your partner, and you gossiping? We found the weakest link, y'all. We found the weakest link. Yeah, I thought it was gonna be fireworks today. I thought Fani was gonna come back, but they actually did the smarter thing, which they were trying to do yesterday, and was just like, nah, she ain't testifying no more. I think Fani just wanted to get at Ashley Merchant and like call her a liar to her face.
I think it
I
was
think that-
January 5th. But just
That's the only reason she came out yesterday.
If it happens to wait just to review the objection again, we still don't.
To which question?
Current question, we still don't know the source of this information, whether it was privileged or how he obtained any.
I'm wondering now if there's a timeliness issue on your objection since he already, well, he said he doesn't recall. So there's,
He just gave the date. He didn't
sure.
start answering.
Well, his question or his answer was he doesn't recall and his memory has not been refreshed. So I think it's time for the next question.
may I approach the witness, Judge?
Okay.
Can I see what you're
Oh, yeah.
approaching the witness with, please? So is this the complete text chain?
Yeah, it's the complete text.
This remind me
While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never
nigga say no.
deleted. I mean, there are messages about family and my health and
Mhm.
things like that. You asked me to be on some panel,
Yes.
and so I think it's complete, but
Well, no, my question was, did you delete?
no,
any text?
I haven't deleted anything.
Okay.
I have not.
That's what I'm saying. You just supposed to say that.
Earlier, they are welcome.
It always be your nigga. It always be your homies. Like the niggas you ride with. These niggas be the weakest link.
It's the only phone I have, Judge.
Yeah. I understand, and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers.
See,
gossiping
Dot, what's good with
about
it?
information. And I'm concerned about it coming into the record in this way. I understand impeachment is a thing.
I thought Fani
but
was
if
gonna
we
pop up
could,
today. You see that?
Do it in a way
This
that
the B team.
substance of this gossip.
This nigga right here, the
is
weakest
not,
link, bro.
That part is not impeaching. The contact is impeaching. So
I don't think we've gotten to that point quite yet, Ms. Cross, but you can renew your objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand him an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any way to download it.
Bro, I stay away from I stay away from Fox channels
That's
as
true.
a whole. I watch Fox to laugh. And sometimes I look in the comments. I was looking at Fox 5 comments. They was going in yesterday.
It's hearsay, whether it's admissible, whether it's relevant, whether it's impeachment.
So for all y'all just joining, let me catch y'all up. Right now is the Nathan Wade's like divorce attorney is testifying right now. Right now they going through text messages that this nigga has had with Ashley Merchant. Ashley Merchant and his divorce attorney, the nigga I forget his name, the nigga that's sitting here right here. They was gossiping about Nathan Wade within within the about Fani Willis and Nathan Wade. It's supposed to be his partner. They texting back and forth about it, and now she using it against him to try to get at Fani and Nathan Wade. Like, that's why he looks so blown, because it's coming out that, like, nigga, like, you crooked. You crooked. You was talking behind your man's back, texting back and forth with the white woman. And now they using it against you, trying to get this nigga Trump off. Boy.
We'll come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think
That's why they keep objecting, because they don't want this nigga to talk too much, because he the weakest link.
as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. I'm sorry, the state scrolled through it, so.
I think it's baffling. I think it's baffling that they even had to. I mean, I get that they was all colleagues at one point. I get that they was all that's why she feel like she had something against them. But they haven't proved, like, the main piece that they gotta prove is the financial gain. Once that nigga said yesterday when Nathan Wade said that he worked for free, that he wasn't even getting shit fully paid out, that financial gain shit gone. Then you had Mr. Willis, Fani Willis' father, this morning talking about how, hell yeah, I told my daughter I always make sure she got some money on her. And what's crazy is that he gave a cultural context where he talked about how he was in a situation, you know, back in his day. It's probably like the 70s or the 80s. And he had an American Express, he had a credit card, debit card, and the people just wouldn't take it. So he told himself then, I'm always going to have cash in case these white folk don't want to take my card.
I'm going to move on to the next question that I actually.
She can't.
Come back to.
Now she looking incompetent.
I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. And you corrected me and say, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay.
So I answer.
Bradley, just a second. Mr. Chopra has risen.
Sorry. Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we've testified earlier, commenced in December of 2018. There is no Pierce or Shield associated with it, and so we would say that under Rule 1.6, we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Ms. Chopra, if I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case, what would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. I can say, based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity in question.
All right, Mr.
Again, this is all about
Same issue.
I just want to reiterate.
staying outside of the bounds of the divorce case and attorney-client privilege in the divorce case. But he muddled it up, though, even communicating this information.
Communication. He doesn't
Yeah.
ever cite the source of where any of this information is coming from, so I just wanted to repeat that objection.
Okay.
Judge,
Merchant.
as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
You did testify on this subject.
testified on this subject.
Well, he didn't testify as to communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify to my recollection, about any communication with his attorneys.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not
Sure.
testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure, unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Per question.
Okay.
And
Sure, got it.
So
All
for
right.
this question particularly, Judge, we would ask that you find that there's.
Damn, I done forgot the question at this point. Miss Ma'am, what's good?
Tied to something. What?
I'm trying to see that.
That's
Okay.
knowledge.
I'm trying to, bro.
Mr. Wade testified as to when they met. That is not the entire substance of the text message that
And began a romantic relationship.
He did not testify that they
Okay.
were serving as magistrate judges when they began a romantic relationship.
All
He
right.
testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you what is covered by attorney-client privilege.
This, yo, regular Joe in the building.
Communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge
Shit, I done forgot the question at this point.
of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier
Yes, sir.
Oh.
that it's a bit narrower than that.
Okay.
1.6 is
I have no personal knowledge, Judge. I apologize.
Okay.
If you
And
were,
that's not a problem. The issue is attorney-client privilege, and so whether
Was-
what you learned, if anything, was during communications with the client.
So, CDOT, they trying to also argue that they lied on the affidavit and that their relationship started before what was being claimed in the affidavit. So they trying to say the relationship started in 2019 as opposed to like 2022 or 2021.
Witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
prior inconsistent statement, Judge, do it all the time. That is what the state does
It's not a
regularly. They bring in, if it's a prior inconsistent statement of another witness, Judge, Mr. Wade
Which other
testified.
witness?
I'm
Okay.
sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And
No,
so
but
we haven't gotten over the privilege hurdle. You said-
The privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you used that word. So if you want to make the argument of why that applies, you can do that now.
Yes,
Look.
crime fraud exception. It applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege.
Nah, get to the fraud. If that's what you claiming, get to the
Exception
fraud.
Says the privilege doesn't apply if if the existence of it, essentially if you
Come
have to
on.
keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
No, it has to. The legal communications have to have done in furtherance. of a-
Selena back in the building. Selena back in the building. They are questioning Nathan Wade's divorce attorney slash
perjury, lying to
business
the
partner.
affidavit filed last month.
yes.
And so, what have you done to link the communications that he made? Maybe I don't know.
Yeah, so he's Nathan Wade's divorce attorney, but then they also had a firm together.
But the legal communication has to be in furtherance of a crime or fraud.
Right. That, right, but
So C-Dot, yeah, they trying to claim that they started dating as soon as they met. That's the accusation.
And everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege. And he waived the privilege. He testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond
Emmanuel in the building. Salute, salute.
throwing out fraud and this and crime, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me, but that's going to be for the court to judge. If a conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. There's a conflict in the evidence for the court to
So I agree with you there that you would have to first establish a crime or a fraud.
Right, the crime, exactly. They're accusing him of a crime when they accused them of the affidavit being false.
under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of...
He shouldn't have been texting with her, though. That's the problem.
Lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Sada.
Yes, this is what I sent to the court earlier. This is not crime fraud. The scenario in the case I said, do you want me to cite it correctly?
We go for it.
Yeah, she's the one, and then she the one who used crime fraud. Now her own attorney, her own co-counsel is saying this isn't crime fraud.
Insurance company et al. And it was 660.
This nigga up here looking sick as a dog. That's what you get for texting with her, bro. She a op. And you gossiping with her about your mans? But why they working through all this? Let me be clear. Some of the worst witnesses that have been brought up for the state to look to that leans against and work against Fani, Willis, and them is niggas.
False. And our position is that Mr. Wade testified falsely.
That's an accusation.
Relationship did not begin until 2022.
That's an accusation.
There are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that. Here, that the relationship, personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired. That if that
Bro, they literally trying to argue that as soon as they met, they was fucking. And that's why Ashley Merchant got cussed out yesterday, because Fani Willis straight up said that you accused me of sleeping with him as soon as I met him.
and the attorney-client privilege under those circumstances, for that material fact is pierced, and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, again, and the court-
But you haven't proven fraud. You accusing the man of fraud.
But if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fani Willis began
Yeah.
2021,
He's saying so even within...
but the witness
So he arguing that even within attorney-client privilege, if there was a crime that was admitted to your attorney would have to then, but that's a lie. Like that undermines all of the entire concept of attorney-client privilege.
in writing, and apparently it's not, is for the court to hear in camera, ex parte, what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages.
And this is where I think the biggest problem is, though. You telling ass nigga. Now, see that I was saying she was cool prior. I did see that she actually campaigned on behalf of Nathan Wade for his judgeship. But it's like, this is post, you know what I'm saying? Like, this is when shit start going left. So I missed the earlier testimony. I was dropping my son off at daycare, like, so I was like the first 10 minutes. So why they was even sending these text messages, I don't even fully understand. I think we need an explanation for that above like everything else. You know what I mean?
Thank you for clarifying your argument there. So I understand this brought upon the cart theory, and what I'd been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now
Right.
by the very person who is attempting to use the communications as a shield to
Sure.
protect his life.
Okay.
And when I say crime fraud, it's a fraud waiver that's what Millich calls it is essentially.
See, and that's why she a fuck up. She ain't even using the right
It doesn't
words.
offend
She ain't even
the
using the
privilege
right
to ask
language.
An attorney to testify to matters already freely.
That's why he
discussed
had to
with the
come in
attorney
and clean
client
up behind her
proceeding.
ass.
Allowing a client to selectively waive and reassert the privilege as tactics dictates, suggests that the client is using the privilege as a sword and not merely a shield.
Sure. So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question was going to be, has that ever been applied in Georgia?
The answer to that is not appears to have been applied in Georgia. I cannot find a case in which.
All right, move on.
The cases that I have, case that I gave you plus the case.
Yeah, let me
that I
turn it
have
up.
there, are the only thing I've been able to locate. Although I think that the bar rules, if we want to go back to those, and I don't have them in front of me, that a lawyer should not allow his client to commit a fraud upon the court.
Okay.
And I think that, along with this.
Peaches, let me know if that's cool.
Discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does it ex parte in camera to determine the nature of the privilege, which of course Your Honor knows from earlier days is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So I'm asking the court to do it, because when I get up, I'm going to ask them directly. I'm not going to go through this that's going on now. To find out
Look.
whether or not Mr. Wade.
He even calling in the question like his own partner, his own co-counsel, saying like, I ain't gonna be going through this bullshit, but I'm gonna ask more direct questions.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words a matter of first impression here, and noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, he apparently, now he's claiming a privilege, which he certainly did not assert when he was communicating in a text.
Look, he like, nigga, what?
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
He hit it
We
with the
know
nigga,
what he
what?
did. We know what he did.
So how's that an implied waiver?
And I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Merchant, asking for sanctions, saying all of her representations were inaccurate. And
They
now
were.
They are
Factually
doing whatever
inaccurate.
they can to block access to that information, which shows exactly what she said was exactly the truth.
They
What
trying.
they're trying to do
They
is
trying.
they're trying to say to the court, the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows, because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, which show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor. The issue about crime fraud is whether or not, in any context, the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed.
I feel like how is that
also
not
know
true for every instance of
when you
attorney-client
look at the
privilege?
attorney-client privilege, the law basically says, look,
In every instance.
privilege which blocks evidence from coming in. So in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Merchant.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client?
Yes. Yes.
And you can tell me if that question was horribly phrased. I can try again.
You try to rephrase it for me, Judge. I'm sorry.
Okay. When you say you
This
lack
nigga
any
looking
personal knowledge,
terrible
Yes, sir.
out
does that
here.
also mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client.
Mhm.
That's correct.
Okay. And communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Wait.
Am I answering your question or her question?
Question.
Okay.
Are there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
Like somebody else was told that information anyway. It was privilege. It would have been privileged, but somebody else was already privy to it. Come on now.
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
All right. And
They really trying to get into this
did
man
you ever
divorce
receive any
proceedings.
kind of a
They
waiver
really
from
trying
the
to get
client
into
at
his
any
divorce
point?
proceedings.
I have not received a waiver.
And anything that you
They gonna be
learned
on this shit all
regarding the
day.
subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
I'm on the motherfucking side of the state, and this nigga annoying me, boy.
That's a broad question, Judge, to answer because the advice was given and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, I can't sit here and say that. So I don't know how to answer that question, Judge.
Out of all the like other attorneys
All right.
that have testified, this
so-
nigga has clearly been the worst. Nathan Wade, Fani Willis, Mr. Willis. This nigga is clearly the worst. The least prepared.
It's Atlanta Coca-Cola Bottling Company versus Goss, Goss. 50 Georgia Appeals 637,
Gary Moore in the building. What's good with you?
1935 decision.
Have not had the benefit of jeopardizing it.
So can't say certain that's been limited or overruled. It looks like it's maybe head note number 2, at least the one I'm looking at on the computer. Language.
A part of the reason why the defense is or the state is doing so much to like really, I guess really to protect this man divorce is because the defense already showed their hand. Like everything that they've literally done from the get-go has been like, we need information about his divorce, period. And so it's like now, like he's sitting here, they playing the game with the privilege because it's the best. It's literally is the best shield against them really trying to get in this man information. Even though this whole divorce happened because his wife cheated on him with a nigga he was cool with. It's crazy.
So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on the witness stand and called into question the statement.
All right, understood, Mr. State. Mr. McDougall.
Your Honor, this is adjacent Georgia law, perhaps not controlling, and I'll explain that in just a second. And that's Rule of Professional Conduct 3.3A2. A lawyer shall not knowingly fail to
They digging
disclose
deep, boy.
a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. A4, that the reason I would qualify that.
So they argument is like we know he
I
lying,
believe this rule
and because we know he lying, and we know that the homeboy that was doing the texting can show that he was lying. That's where they get in the assumption from the perjury from. And I mean, and he put it on the signed affidavit. So
All right, fair point. Okay, Ms. Trooper, anything you want to address on that end?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. He's called him a perjurist. He is officially succeeded in saying the thing itself is true. Therefore, we must
agreed.
ask these other questions. And Judge,
Agreed.
it's a fallacy. It does not exist as
it's an
such.
assumption. Like you, this is
Still apply.
right.
guilty until
Thank you all.
proven
So,
innocent,
I
not
think
innocent
here
until
is
proven guilty.
What we need to do is, I understand the law. As I find it, the crime fraud exception only applies when, by preponderance, we found that communications made in the existence of a relationship were in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, that the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point, and so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed and until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege, the premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you.
All right, so the judge is like, what's it called? The opposition is sustained. You know what I'm saying? The objection is sustained. But to answer Peach's question,
right, let's see.
the state is trying to say, oh, no. The defense is trying to say
Ms. Willis
that
and Mr. Wade coming to and from your office.
dude right here, Mr. Bradley, has
follow-
prior
do you recall
information,
that?
has information that can prove that Nathan Wade perjured the court.
Do I need to look at my phone?
No,
Or can I just-
They're trying to say that
do I
we
recall?
have
I think I
evidence
did.
that he perjured, and
security
Mr. Bradley has that
Ms. Willis
information.
To your office.
I object to that.
Does he recall
Actually, I
Ms.
take that
Willis
back. No,
taking
I don't.
security?
You can answer the question, sir.
I do recall security detail bringing Miss Willis to my office.
Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
I just don't see why they would.
So I don't know if she
lie.
had
Yeah,
security
that was a
detail
good
before
catch,
she
Blue.
became DA. So
And that's what I
I
was
mean,
saying. He was
if she
definitely
was sworn
guilty
in,
until
or
proven innocent.
I don't remember the dates, but I do remember.
I just don't understand why they would lie. Well, no. I do get why they would lie. Never mind. I
think she
just
was
feel
DA.
like who wants
Maybe
to?
during her transition team period, was that?
No, it wasn't. Trying to remember.
This nigga. I feel like his credibility shot. That's why the judge is like, all right, we'll sit this nigga behind the scenes, protect. You know what I'm saying? Protect whatever is privileged.
She would have had
and
to
then
have
just so we could
been
put that on the record. But this nigga seemed like a liability. I
the
ain't gonna lie to
DA.
you.
I think, and I don't want to go on. I think, but I do remember twice.
Peaches, the defense. So
coming
Ashley
to our
Merchant, this
office.
white woman right here, they
And
want
she had a security team
the
both
they
those
want the
times.
divorce information because they, from their position,
That was
and they actually
a-
got the divorce information, but they
Yes,
want to
she
try to
has security
use
team
any
with it.
detail they can from the divorce to try to make it
and
seem
do
like
you
they
believe
had a
that it's a different
relationship
security team
prior
than
to
she has now?
2022. Because they filed and sworn
I don't know her
affidavits
security
that their
team now.
relationship started
Well,
in
however-
2022.
I'm
They're-
sorry.
but the defense is saying it
I
started in
don't
2019.
know her security team now.
Oh yeah, see that they lost the financial gain argument. They lost that yesterday. So now they're
I
just
don't
trying
know
to
her
get them on
security team
perjury.
now.
They're just trying to get them on line on the affidavit and lying in the
Security
court.
team.
Yes, I think I recall saying that. Yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that. No, but
Do you recall talking to me about other people that might have known about their romantic relationship?
Hey,
I recall.
attorney friends, man. Like having friends in politics, that's
Based on, you don't know
wow.
the source. I mean, this is either based on privileged information or it's hearsay. Year one.
It's
She's like, do
neither.
you
I
remember
asked
talking
if
to
you
me
recall.
about our
you need to
friend?
clarify it. If you're actually going to think, if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. So sustained.
She
Are you
stay
aware of
getting her
other
ass
people
subjected.
that
She stay
you
getting her
believe
ass subjected.
would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right.
And that's what they use
Okay,
in
Ms.
these
Merchant, I think we're getting to the point where
to get up under her, like
you
to,
know
to
the
block
reason
her
I
trying to
thought this
use
line
their
of
personal
questioning
information.
was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So
They
maybe you
need to
can
get
ask more.
They got to
overarching
get it to the
questions,
granular level
and if you
because
have
that's
anything
the
else you
only
think
way
that's
that they're gonna
relevant,
prove
then
the perjury.
you can get
Are
to
they
those
gonna
as well.
think they could prove the perjury?
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and you.
Objection.
Okay. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege and that he did not have the ability to waive. So I think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege, I think.
Well,
to
I
preserve the
think he's
record.
pretty much already established the privilege and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see.
Do she need to get fired? Hey, how many of y'all think she deserved to be fired? I mean, this was a Hail Mary already. Do y'all think
And
she
you
doing
had you had knowledge
okay
about an
job, even though
apartment.
they never
I'm
had a
not
chance?
Asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that. So
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Do I?
Have you ever?
I have.
Group text.
Maybe once or twice, but
Where y'all group text? They wasn't saying no shit about their relationship.
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection
On
on privilege. I mean, just still same thing.
just
No,
asking him to
it's-
use a credit card, how's that in the nature of furthering a divorce proceeding?
Yeah.
All right.
I had a business card and we would use my business card. The firm would use my business card.
For travel?
For travel, nigga.
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
This nigga.
I recall,
Took that low to be like I recall.
I recall a trip. But
Everybody
I
handled
don't know
this
if
so much better than him.
that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that's the honest truth. I recall him using my card once,
Hey, everybody
but
in
I
the chat.
cannot remember
What do y'all
what
think of
that
Mr.
was
Bradley?
for. I do remember it was a trip.
What is y'all opinion
But
of
I
Mr.
cannot,
Bradley, man?
accurately say
I'm because I'm looking at
whether
this
it
nigga
was
like
and
the weakest
who it
link.
was with or
But y'all let me know what y'all
anything
think.
like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office.
But this
And
is-
so
Oh, I'm sorry. I thought you were done. Sorry.
he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have that business card anymore. But
Brady said definitely the weakest
I
link.
do recall
Facts.
at least once for travel. Yes.
And that was when you were still law partners with
Miss
him,
Ma'am
correct?
said
That is
he's a
correct.
mess.
Do
He
you
is
recall
a mess.
approximately when that was?
I do not.
You
Gossiping
did not
about
go
your
on that trip
partner
with
to
him, though,
this.
correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes. I mean, I'm assuming. I mean, we would use the card for firm stuff, and so it was a business card.
Even the judge is like,
Your
this shit
business
is
card, though.
It
useless.
was my business card. Yes.
Right.
The law office of Terrence A. Bradley. Correct.
So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his accounts, though, correct?
That would be accurate. Yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Miss Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office.
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the taint team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
That's about a straighter answer we didn't got from this
Let's talk
nigga
about
this
that for a
whole
minute. Tell
time.
me about you did work as, you had a contract as a taint lawyer, correct?
That is correct.
Okay. And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean? How did I get it?
How did you get the contract?
It was,
Bid? Did you apply online?
oh no, it was proposed,
By who?
we were, it was proposed by, I guess
Come
it
on.
came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was.
Because Fani talked about this in depth yesterday. She
with
talked
Mr.
about this in
Wade,
depth yesterday. So
and
this
he
nigga
asked
about
if
to-
we would be interested in having a contract with the Fulton County.
Okay.
Y'all see how they trying to criminalize, like they literally trying to criminalize like networking that everybody does. Like, oh, I know somebody I could, get y'all connected, and then you get jobs that way. That shit is
We all
normal.
handled several, different things for the firm,
Okay.
criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Did, was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was a part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
This is a weak ass line of
You
questions.
said most of his time, are you saying just working business hours, or?
Working business hours.
I would say he spent,
Mountain out of molehill. Trying to make a
I
mountain
would
out of
probably
molehill.
say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
And that was the entire time from when she took office to when you left the firm.
I can't say that that was the entire time, but yes, it was majority of, it was I can't pinpoint specifically when the time that he would spend. I think, if my memory serves correctly, getting to the majority of the time, it would have
This
been
nigga here.
whenever he started.
Out of all the
with this,
attorneys that
maybe.
have
That
testified.
was
As a special prosecutor?
when you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. Depends on what you say is a lot. He spent time at the DA's office, correct?
And so just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
This
Repeat
nigga
the
got me
question, I'm sorry.
yawning.
You and Mr. Campbell
Yes.
both
Jeez.
were hired
Mhm.
on a contract basis by DA Willis
Mhm.
January 25th.
Everybody else been kicking Ashley Merchant ass. This is the only nigga that seemed to struggle with this woman.
Okay. Well, you said the first one, and the tank contract wasn't the first contract. And so,
Okay, so what was the first contract?
to my knowledge, the first contract was the first appearance.
Okay, so let me just mark these. Let's see, what number are we at?
Now, Fani explained this yesterday. You know what I'm saying? When she got to the
23,
DA's office, they were understaffed. It was a mess. You know what I'm saying? So they went through
25.
this huge hiring shit where they was hiring people to handle first appearances. And I think that's when she first got connected with dude. That's what she explained yesterday. And so they kind of revisiting the information that was explained
Judge,
more
when
in
they're
depth
done,
with Fani. She got way more in depth about this. And again, all this is like criminalizing black people networking. That's it. Ms. Ma'am said both of them are making it very evident that all lawyers are not good storytellers and great communicators. That is hilarious. Shit, this is like an ugly fight. Like two people who can't fight. just swinging and missing. You know what I mean?
Just
He ain't
show
doing
me
his
what you
job. She ain't doing
Exhibit
hers.
23, 24, and 25. If you could just take a look at
This is a
those.
terrible matchup. This is like if you take any sports league, take the worst two teams, the bottom two teams at the conference, and you know, have them go up against each other. Foolishness. You're gonna see foolishness. That's why this shit been so drawn out. The only reason you keep getting objections like that is if you don't have finesse. If you can't ask questions in a way that is slick enough to get by certain privileges, but then at the same time accomplish what you need. I'm interested to see, because them other lawyers, more one in the building was good with it. Them other lawyers, even though like they case is terrible, they do a much better job. Much better job. So that's why they get Ashley Merchant out the way, so that they could come in and kind of clean this up. I feel like Mr. Bradley here is gonna struggle when the good old boys get up there and get on his ass. He gonna struggle. And what's crazy is we still seeing these white people put they brands and they names behind Trump.
Okay, I see that.
Like
So
with Trump reputation
now
and
that you
everybody
read those,
reputation
is it true that
collapsing.
On January 25th, 2021, you got your first contract as a taint lawyer.
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been. I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, if I had a written contract at that particular time or anything, but I do know, I think that you can look at the recordings because everything was recorded at that time.
Yo, and in debate, my coach would always tell us, like, even if we felt like we was losing the debate, you can't be sitting there and look like you losing. He looks like he's losing. He looks hurt. It's not helping.
And then at least two contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, it just renewed. So yes, if it was the same contract, but it was a renewal of the contract.
So how did you, and you said you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Nah, more one. That's why y'all ain't been listening. Y'all must not been listening to these hearings. Cause I'm telling y'all, anybody got any smoke for Fani?
I didn't have a meeting with Ms. Willis.
I'm telling you,
or anything.
Anybody got any smoke for Fani? Let me go ahead and put this out here in YouTube land. I'm telling y'all, what y'all think y'all know about this case, y'all do not know. I guarantee it. I guarantee it.
If I was interested, because this was off of mine, and I said yes. And so
Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct. And then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
And so that is how you were paid from Fulton County, these contracts?
From Fulton County government? Mm-hmm. Yes, ma'am.
And you shared your partnership, you shared a third of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had two filter teams.
Okay, all right, my bad, more one. I'm just in that.
Two first appearance
I'm
contracts,
in that mode.
and you had Mr. Wade's special counsel contracts, correct?
I'm in that mode. That's why we here.
My firm had what I have here.
Okay.
But
Correct.
But
this is
Mr.
what you
Campbell
call
and
a
Mr.
low
Wade were part
light,
of your
though.
firm, correct?
This shit is a low light of this whole shit. The highlight was yesterday.
So we didn't. I don't think at this time we had established WBC.
Okay.
At this time, I think it was
There's
had
nothing
mine.
impactful coming from this.
Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared.
At this time, well, yes, at this time, we were not. If we were at this time, I had Law Officer Terrence Bradley.
That's all she has done this entire case.
PC,
Oh, you would make a statement, and her next question would be literally what you just said.
if I'm not mistaken.
Yeah, nah, we weren't partners, we fee shared.
And all
Oh,
the
so you weren't
contracts
partners, you fee shared.
And the Nathan special counsel contracts, all of those were under the anti-corruption unit, correct? You can look.
First appearance was not under that. The tank contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the tank contracts
Mhm.
and then Mr. Wade's contract, which has already been admitted in evidence. If you need to look at that.
Yeah, yesterday was the show, y'all. I was excited today because I thought because she was supposed to come back and testify this morning, and have the state ask her questions, and I thought she was gonna go through those filings and rip them filings apart. But I think they took the smart route and was like, we're not gonna give them no more ammo, so we just gonna allow them to try to build their case. But she was like, I gotta holler at y'all though. Like we gotta have this conflict. Like you gotta see me for all the shit that you've been lying about. You know what I'm saying?
First page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
Oh no, take your time.
Regular Joe. I'm telling you, bro. I've read every filing. If you have attorneys lying on your name in court filings, nah, it ain't no doing too much. You gotta see me. You telling me I slept with this? You telling the people I slept with this man as soon as I met him? Yeah, you gotta see me.
FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the district.
For.
I work for the DA.
Okay.
I work for the DA.
Okay. So just in general, the DA.
Correct. I work for Fulton County District Attorney's Office in as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen.
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Y'all hit that like button if y'all ain't hit it yet.
Let's see. So I know you said you met with Miss Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Hey, I'm nervous for when these other attorneys
So if
come
I
up here, man.
meet with, I mean,
Sat down and had a conversation with her.
They talking about what meet with? What you
I
mean?
signed
by
these
that?
contracts. So when I signed these, I met with her to say that I sat down and spoke with Ms. Willis. Are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't. in
Ms.
the-
Merchant, I haven't really heard a point in a while. Can we get along to something,
Yes,
or we're gonna have to
yes.
wrap it up?
Look, I
So
done
have one
told
more
y'all,
question
she
on your text.
trash.
Have you ever been in any group text with anybody other than
She trash.
with me and somebody other than Mr. Chopra and Mr. Merchant?
The judge had to tell her like, hey,
Narrow that down. I'm sure he sent many
I can
texts
look at
over
my
the course of
phone,
his
but
So
life.
with him, if there have been any other texts, and I think that the state had some
Him
things in rebuttal they
being-
mentioned, so I was just trying to clean that up before it got there.
this is what happened when a judge is fed up.
Can you try the question one more time for
Yeah.
me?
This is what happened when a
Isn't
judge
it
is
true
fed
that
up.
the only texts that you and I have ever had have been between me, you, and Mr. Chopra, or me, you, and John Merchant, correct?
Can I look at my phone?
Sure.
That's crazy. You can't have friends in the legal system. You cannot have friends in the legal system. She
what's the
using
relevance?
They've
personal
said multiple times that
personally-
there's this third party that we've talked to, and I'm trying to establish there's no third party. And I don't know why it was relevant, but the state's argued it. So
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might
Okay.
become relevant later, but right now.
Ms. Merchant, I
Yo.
think you've been able to show
She embarrassed herself.
what maybe launched this and answer the
She
the state's
embarrassed
initial
herself.
claims. And so let's get back to the core of what we were here for this
Wow.
hearing. Do you have anything else relevant to ask? this
Wow.
witness?
after yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd.
Bro, she literally just told the judge that I don't know why it's relevant, but they brought it up. Then why are you talking about it? Bro, they just be giving everybody law degrees.
When he called,
She
It
said,
was
I
out
don't
of
know
the
why it's
blue.
relevant.
but he did call. Yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call. Not
This
that
is crazy.
a message that was supposed to be relayed to me. The call was,
I'm going to check if there's a hearsay, if the response will call for hearsay. Thus far, it hasn't.
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
And
Hasn't testified to it. And he also said there wasn't any message relayed by Mr. Wade or any other party.
She's trash.
well, no, he didn't say it was by any party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a
You fucking up.
if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right. So
I did not take it as a threat.
Boom. Cleared it up.
if you're saying it's to the effect on the listener, perhaps,
Yes.
then we'll go from there.
Were you told to remember your privilege?
Your Honor, the witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection and the testimony given the weight it deserves.
Okay. Yeah, let's go.
Can you repeat the question?
Were you told to remember your privilege?
Your Honor, can we,
I was not.
the witness, there may be a potential witness now in the courtroom because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his
All
name.
right. Okay. And so were you told anything to that effect, Mr. Bradley?
You said no.
Repeat the question one more time. But
This
so
nigga
I was not
here.
told.
Oh my God.
Remember my privilege.
Something about privilege. Remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, you know, a threat of any sort.
This
You
nigga
called
here,
me
man.
after.
No, I
Look,
called someone else after.
You called me quickly thereafter then.
I talked to you that day. Yes, ma'am.
Okay, thank you.
Let's stay down.
yo, did y'all hear what she's like? But you called me, right?
Is it the state's first cross?
We,
That's how we had been doing it yesterday.
No, actually, we're doing it just this way.
yeah, I've been. This,
Okay,
this is
I
the first
apologize
time
then.
he's gone, and then we go through all the defense, and then you'll have your chance.
Yo. Yeah, she's trash.
Some foundation questions to begin with, please.
He a threat though.
Your testimony is you began representing Mr. Wade as his attorney
This
on
is gonna be
what
annoying as
date, or
hell.
what
I'm
approximate date?
telling y'all right now, this is about to be annoying as hell.
I didn't have an approximate date.
Then give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, you know, if I'm speculating,
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
He
right.
on his ass.
Give us
I told
the
y'all.
ballpark figure of when it was that you began acting as his attorney.
Now he about to get worked.
maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained.
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yes. Yes.
Okay, good. Now,
Hey, tell me if
Did
y'all
you
feel the
ever
same
meet
thing when it's
with
like waiting for him to answer questions. It's like
Miss
nigga.
Willis and Mr. Wade, prior to, and everything I'm asking you was prior to November of 2021, okay?
Okay.
Keep that in mind. That's,
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sadal, let's go.
thank you. Prior to Mr. Wade getting his
He annoyed.
contract with Fulton County, which was November 1st of 2021,
Nigga,
okay?
whoa,
Just
man, get
please
your
keep
wits
that in
about you.
mind.
November
wits about
1st of
you. Stop-
2021.
Right.
Don't
Did
make
you
this
ever
shit look
socialize
painful.
with Mr. Wade and Miss Willis prior to November 1st of 2021?
What?
I've never socialized with Mr. Wade or Miss Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat
Got up
with both of them?
drinks. Yeah.
Before 2021, I do not
Or
think.
November 1st of 2021?
All right, since we know how silly that question is, so we're gonna answer more one's question in the chat. Are they trying to frame Fani for adultery or misconduct with the coworker? They trying to set her up with misconduct with a coworker for her own financial benefit. So they trying to say that the only reason that he was hired was so that he could get a financial benefit, so she could get the financial benefit from him being hired. And it's decent that you asked that question because like this is all they've been asking about and they have no evidence of this.
January 2021, so yes, I mean, it would be before November. So if it was January, yes, that dinner would have been in, I'm assuming January.
And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is.
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
Okay, all right, he's starting to
Prior to November 1st of 2021.
get loud
Did
back.
Miss Willis come to your offices? Your offices, I mean the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall,
Peaches said so she was not allowed to date someone in the department. Actually, she is. That's what makes all of this bullshit. They're trying to say them dating was for her financial gain. That's what she tried. That's what they're trying to disqualify under. It's not that they had the relationship. It's that the relationship was used for Fani Willis to gain financially. That's why they're trying to disqualify you.
I want to say DA's office there, maybe.
Okay. Let's go back to the basics. Miss Willis came to your offices, together offices.
But they haven't been able to explain.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those.
See that it ain't even frowned upon, bro. I show you the court precedent, the Georgia precedent that said it ain't even frowned upon, bro.
Or heard.
I can't recall.
You can't recall.
No.
Did she ever meet with you in your office? Miss Willis now.
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Miss Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized.
With Miss Willis, correct.
And I'm saying I cannot recall if he socialized with Miss Will, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Miss Willis? Again, time period before November 1st of 2021.
Would this be before November 1st? But the what's the name is still going on, so I don't know. That's why he's trying to not get caught up. But it's like y'all should just go ahead and objection, privileged.
Did he repeat your question?
Did Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
Now Nathan Wade said no. He didn't talk to nobody about his relationship.
I'm sure he did, maybe. I don't recall any specifics of any dinners, any
I don't recall is all you need.
Specific places.
I don't recall.
I mean, it's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was
These
staying
questions is bullshit though. I'm gonna just be the whole honest with you. Like they not proving nothing.
That is, the question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
So you don't recall, nigga? I don't recall.
I don't think I can answer that.
Spot. Thank you.
Mr. Stadoff, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
Y'all been letting him ask the same damn questions.
Just, I didn't hear a second ground. Well,
There's a hearsay ground.
oh, that would be on privilege alone.
Privilege ground. Yeah, make that nigga
Did
ask
you
that shit
talk to
differently.
Mr. Wade at all about his relationship with Miss Willis prior to
Objection.
November 1st of 2021?
I think he's just laying a record, Mr.
Thank
Wade. It's
you.
okay. And so on those same grounds, Mr. State Allen, all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well,
So
I
you
think
got to
he
ask him in his
respectfully,
personal.
Your Honor, according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
In the personal
So then we
capacity.
need to acknowledge the privilege in the form of your question, right?
So you got to ask him in your
You're asking me
personal capacity.
To ask it as in a way saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
In a personal capacity. I can't recall. Come on. That's how
I
this
mean, we
supposed to go.
discussed this contract,
That's not Miss.
but
This contract doesn't help you.
Nigga, if you don't just say I don't recall
you said
and move
before
on.
November 2021.
Yeah, November 1st of 2021.
Before November, this contract for 125/21 is
Exactly, Miss Ma'am.
I mean, we discussed this contract.
Exactly, Miss Ma'am. We're
correctly,
grown men. We don't kiss and tell.
Just give me that exhibit number so we can reference.
Exhibit 23
Okay, hold
would
on
have
one
been.
second. 1 second. On exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Miss Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was the relationship at that point between Miss Willis and Mr. Wade for Mr. Wade to be able to bring you to Miss Willis for the contract?
Colleagues. They were colleagues. They were colleagues. They were colleagues.
Not a hard question. It's
No,
really
I'm
simple.
just state that again.
Mr. Wade is the one that basically says to you, go see
I
Miss
thought we was gonna
Willis
get
about
Fani
this
today. We
contract,
get this
right?
nigga.
That's a yes, correct?
That Mr. Yes.
So
I
Mr. Wade
apologize.
had to have some knowledge, you would assume,
Yes.
right? That
colleagues.
you going to Miss Willis might bring you the contract.
I
right?
never
Say it
went
with
to Miss
me.
Willis. So
They were
I stated
colleagues.
I never went to Miss Willis. I was told about that there was a potential contract, and that I was asked by Mr. Wade if I would be interested in doing that contract.
My
I
question-
never.
Okay, my question to you is, what was the basis that you understood Mr. Wade being able to potentially offer you that contract for on Miss Willis's behalf?
I object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the
He can answer this though.
relevance of this.
They were
at all.
colleagues.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question that's standing unobjected to, Mr. Bradley?
Can you repeat the question?
They were colleagues. If this nigga
You
can't just
explain
say
to us how
We
the
can say-
contract
Yes.
came to you, correct?
Yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Miss Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest
this
in the
nigga here.
Privilege.
All right, Mr. Evans has invoked privilege on that question. So Mr. Sadao, I think you need to clarify whether,
Was it a privileged conversation that you had with Mr. Wade that let you know
I'm not an
about the
attorney.
contract?
He's
or,
he's
you know,
actually
the
attorney. I'm not
relationship
an
is the
attorney.
question you're focused on.
Is the nature, no, I'm trying to do it in such a way, and I understand what the court's saying. Was the relationship that I asked you about just now between Mr. Wade and Miss Willis that gave rise to the
Marcel
contract?
the Great in the building. Appreciate you joining
Did you
us,
know
family.
about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together.
This don't help, bro. All you gotta say is they
as
was
municipal court
colleagues.
judges.
They trying to make it seem more than it was.
How did you know that? Who told
And-
you about the work that they did together as municipal court judges?
Mr. Wade told me that they
Were
worked
colleagues.
at some conference.
Okay, now, this would have been something that Mr. Wade said, according to your time period.
Oh God, this nigga starting to piss me off.
You were representing Mr. Wade, correct?
Did they not prepare this nigga?
Say that again. Ask that again.
Oh,
Mr. Wade would have told you what you just told the court
it's this type of shit that undermine credibility, bro. You can answer this question.
with Mr. Wade.
What did you assume was the nature of their relationship? Well, they were colleagues. We were all in the legal
Yes,
arena.
but when he told me of them being at a conference, I mean, I don't.
My boy Tyler
Nah,
T Bird.
no.
Yes, this is live, bro. This is live.
How I relate. I mean, I'm trying to understand your question.
My question is
It's
basically,
not.
you had communications with Mr. Wade directly that
Yes.
was not attorney-client privilege.
Y'all let me know if I'm tripping or not. Miss Ma'am said no. No
I just
additional
stated
info.
that they were at a conference. I don't know whether or not that involved her or not.
That was my fault. See that I got
He's
it.
talking about her, that is, if Mr. Wade is telling you about Miss Willis and Mr. Wade having met at a conference, right? Then he's talking about Miss Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Miss Willis as well, correct?
I
Yes.
think so. Yes.
So there were communications in which Miss Willis was at least a topic that was not covered by attorney-client privilege, correct?
Tyler, text me, bro. Text me.
This particular instance, I was told about a conference, and
And when were you told this?
When was the
I
conference?
can't remember the dates of the conference, but it was after. It would have been after the conference.
It was
I'm trying to get
2019.
the time period here. After the conference, I want you
Malik
to
Rain in the
understand
building.
from
What's
the
good with
record,
it?
I believe we've shown that the conference was sometime in October of 2019.
2019.
So
That's
could you
been
give us an
established.
idea, that being a fact, when you would have had this communication about meeting with Miss Willis at the that is, Mr. Wade meeting Miss Willis at the conference?
If that's the conference that they were at, yes, then I don't know how many municipal court conferences there are. I do know that.
Yeah, bro, I
at
get
the
this
time
nigga
that I
a
was in
F.
the firm, Mr. Wade was he had some position with the municipal court.
Yeah, right now,
as-
my only question is time-wise, assuming it's October of 2019.
Because I don't even understand how we
tend to
went
remember
from.
What's your best recollection of when Mr. Wade?
How did
told
you get the
about-
contract?
I
to
can't remember
when
because
they
I didn't
met?
even remember that it was October 2019 until you said that.
So you don't have a present recollection.
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Miss Willis meeting at the conference had to be before.
Oh, yeah, yes, it would have been before that, yes.
So
Oh, my God.
What other communications?
That's
did you
what would
have
make
with
them
Mr. Wade
colleagues.
about Miss Willis that are not privileged? We know of one about the meeting at the conference. Are you suggesting that that's the only one you ever had about Miss Willis that isn't?
I cannot recall any. I cannot recall.
He
Cannot
let
recall
he
whether there
let
were any
the
other
defense set
communications
him up for
weren't
that.
privileged?
He letting the defense set him up to look like he's lacking credibility.
No.
This is crazy.
Well, I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Miss Willis?
No.
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again.
You don't have to answer the
No, it's
question.
sustain.
Next
This
question,
nigga
Mr.
ain't
Evans.
even. He ain't even keeping up. A question he ain't got to ask. He asking him to
The
repeat.
court has sustained the objection. Can you tell us the
This nigga
circumstances
aggravated.
in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice, seeking
See,
advice.
he opened this
So,
up instead of just
Those are the
saying
basics. If I
they
can
were
ask you for all
colleagues.
those, but if
Sure.
the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that. And cover
All
that.
of this prior to November 1st, 2021. Okay?
because that's when he got the Taints contract. So he's trying to
I'm going to
figure
show
out,
you.
Did
two
you have any
text
conversation
messages.
about her before the Taints contract? And it's like, how did you know him? Like, what was the nature of their relationship? They were colleagues.
This is
Because they not saying shit. I mean, every time they tried to say personal relationship, Fani and yesterday and Nathan Wade would say, yes, we had a personal relationship. We were close friends. Another word for close friends in the professional industry is we were colleagues. We worked together in the legal field. They even admitted to having a mentor, a mentor-mentee like relationship. This is already on the record. So for a nigga to be thinking like, okay, yeah, like the way that she connected me is through our professional network. They were colleagues. I just, you know what I'm saying? So it's like this, like, so the fact that he's trying to, like, he's, instead of just being clear about what he understood about, he's trying to call it into question, it make it seem like it was more there than what it was at that time. They make it seem like it was more there than what it was at that time. Instead of just saying colleagues. That shit crazy to me.
I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. May I approach?
You may, sir.
This man credibility shot. Peaches said, why isn't his lawyer not objecting? Actually, he had popped up, and then the judge seen him. He was like, I already know what you're objecting about. That's sustained.
Yeah, look at this.
So you ain't even got to answer the
message.
question.
This part.
All right, look, can I read it first?
Of course, of course.
Yeah, bro. And then the fact that this nigga look like it hurts to be on the stand, that is not helping.
And then this
Like
is
his
the
face
second
been
one.
scrunched up, like he
follows right
constipated the whole time he been sitting there. That has not helped his testimony. Yeah, man. If the real highlights was yesterday, the people said they wanted to hear they want to hear the rest of it, so here we are. But this nigga here, man,
Kind of hard to object. That's
As-
the question.
as exciting as it was yesterday with Fani,
Then you
This
must be a
shit-
soothsayer.
complete
Bradley,
opposite.
I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, yes,
Okay. And the text messages would have been between you and Miss Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Miss Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm gonna
I haven't asked him anything about what the,
flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were.
Peaches said he looks
Alright,
confused
understood.
and unprepared. Regular Joe
Yes.
said he got the bubble guts. That
And
nigga definitely got the BGs.
it's your testimony that
He gonna run
the
straight to the bathroom
information
after this.
that you imparted to Miss Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is, we've already established the privilege.
Well, no, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, I don't see an issue there.
Ooh,
Yes.
he may just got
And
caught
is
up.
it your testimony that the knowledge that you had, which you
He
imparted
may have just
in
fucked
these
up
two
the
text
the
messages
privilege.
came from Mr. Wade and Mr. Wade alone? Is that
Yes,
correct?
yes.
Can you
Yeah,
tell
he
us
fucked
when
up.
it was that Mr. Wade imparted this information to you?
Objection.
All right. And I think
That's what you're going to do. And
sure. So I'll sustain that on privilege.
And I'm going to introduce for the record, when we finish these two text messages, so that Your Honor has those back there, so that you can,
Sure. What would they be marked as?
what do you have?
I have a whole set. You can mark.
Yeah.
Okay.
So what they arguing now is that you communicated information that you had about Mr. Wade, about Mr. Wade to Ashley Merchant in these text messages. We don't know what the text messages is
Once I
yet,
put a
but
staple in it, I think
they're
we'll
saying
be-
that they had that information that he kind of violated this attorney-client privilege already when he was communicating with Ashley Merchant. So when he say he don't recall having conversations about Miss Wade outside of any attorney-client privilege, then where did you get the information that you shared with Miss Merchant?
This is not
Evidentiary value.
This is for purposes
Now I
of
see why he's
court
sitting up there
conducting
looking
a
stank.
formal review.
Because they got him by the balls,
Put a
for real,
staple
for
in
real.
it here to make sure that you see.
It's not looking good for him. Not looking good for him. Going back and forth texting with this white woman about your homeboy,
All right,
about your
Mr. Sarah, what else?
ex-business partner. Now, to be honest, they still have
All right,
done
so-
nothing. They've destroyed his credibility, but they ain't did nothing to prove
There was also reference,
what it
if
is
I
that they're trying to
remember
prove,
correctly,
though.
to some email correspondence in which Miss Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
Ashley, do we know?
He's responded by text.
You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but
Okay, I'm gonna get it for you because
okay,
I don't want
all
there to
right.
be any assumptions. As soon as we have it.
He's like, "Oh, we got the text. Do you need to look at your phone?"
Let me
Come
show you.
on,
This is-
bro. Avoid friends like this. This whole. If you don't take anything else away from today's testimony, hey, watch who you around. Shit. Watch who you around. Shit, if you got your business partner like texting back and forth about your business with other people in the law community, boy. And then when you ask them why would they want to keep their relationship private, shit, it's shit like this. They using my own nigga against me because he was running his mouth.
Is that what you're?
I'm gonna ask you about.
But I feel like they found people who had like some
I'm gonna
type
show
of
you
negative
if I might
experience
approach.
with Fani and Nathan to try to
I made
try to
reference
drum
to
it
an
up.
email
These was
that
these
Ms.
was they
Merchant would've
2-star
sent you
witnesses.
about
The hater
the,
ass homegirl from yesterday.
motion she was gonna file. If you look at this, does this appear to be the email
And
that
this
you
nigga.
received? It's dated January the 6th, 2024 at 10:20. Can't make it as 5 or 6, 10:25 a.m.
Yeah, I see it, the email, yes.
So that's the email that you received. Along with
Served
obviously
himself
the
a
attachment,
big L, more
which is
one.
referenced.
A big
Yes.
L.
Okay.
That's why he looking like
And
that.
then, did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay.
You told her the disqualification looks
as-
good, but
Another exhibit for your honor to look at.
dirty ass nigga.
Since you love my tone, can I have a sleep?
Dirty ass nigga. Oh, bro, your boy, your ex partner in one of the biggest cases of his career. You man, watch who
Okay,
y'all.
I'm gonna
around.
have these marked as 27. Okay?
Tell Austin
All
I
right,
said,
so
what's up,
is it
Tyler?
your position that what is reflected, let me hand it to you.
Tell Austin I said, what's goody? Man, it grew up on
What's the
us.
course rule, to ask or not to ask?
We'll take it case by case. I think he's doing all right. So. no
Do
need to
y'all
ask for
hear this?
witness.
It's black people that done got in our
Is it your-
own way.
Position that your response, which is the second page of Defense Exhibit 27,
Black people getting in their
is based
own
on
way.
confidential communications that you had with Mr. Wade.
They got him by the neck. Y'all talking about this confidential shit. Why is he out here bumping his gums in text messages and emails about what's going on? Oh, boy.
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and he knows it.
All right. So now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response was privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
No. Was your response to the email of Ms. Merchant, which is on page 1?
Was the response
Is your
based
response,
on...
which is on page 2, is that based on knowledge that
You
you
can't answer
received
that.
from Mr. Wade pursuant to confidential communications?
This is what you call a
Yes.
double bind. Ooh, so he just admitted that he violated attorney-client privilege with somebody else? Oh, boy. So you was bumping your gums about privileged information to other attorneys, to adverse attorneys. Oh,
Have you
nigga,
discussed
it be your own
with the district
people, boy? I'm
attorney's
telling you.
office, this case, your purported testimony?
Of my testimony?
Yes.
No,
At all?
no,
No prep, no conversations, no nothing?
no.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
privileged
sustained.
communication.
Let's stay down. Next question.
She said,
Do you know
yeah,
whether
you
or
gotta
not
say
your
it right.
attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorneys shared or didn't share. I don't know if they even met.
Ah, boy. I mean, I don't know who this works against. The attorney that was soliciting attorney-client privilege-based
Last
information.
question. Have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee-sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee-sharing partnership, pseudo-partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee-sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I want to leave and go out on my own, yes.
Understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question.
Did y'all split amicably? Was it cool?
Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Miss Willis?
Oh, no,
Okay. Did it have anything to do with your conduct?
no.
Did it have
Wait,
anything to do with his conduct?
hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed.
Get it out.
And so we dissolved, well, I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
I don't, if you define misconduct, I'm telling you, we had a disagreement and
Just tell me what the disagreement was then.
the disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged
Oh, it is privileged.
It
Why
is.
is that privileged?
because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis.
As it a connection to Miss Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else.
Do
Oh,
y'all
yes.
hear this?
So
man?
will it apply as to whether I was hired during the divorce? Yes,
Ah,
that's correct.
Boy,
I'm
get
not
this
sure
nigga off the stand.
what this correct means under that. We kind of got lost on it.
You asked the question.
Did not relate to your representation
It would relate to my representation.
in the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I'll have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I'll have to look at the filings. I ended up hiring
the defense's
new counsel
questions
for my
have all
construction
been the
case.
same
He ended up,
shit.
but it wasn't right at that moment.
Like
It
they
wasn't
trying to like big up
in
like
a matter of weeks.
small
It was-
details to try to make it seem like it's something there,
I don't
bro.
know.
Continued
It's,
representing him in connection with the
these questions have
divorce
been
case
trash.
after you had the separation that you've made reference to.
He continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Miss Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sada, I think we've.
Would such
covered this.
information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent
No,
without getting into the information itself.
I think the issue would be that we've already gotten an answer on that, and now we're asking the same question again. Ms. Merchant asked him a variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has
Joe.
information from whatever source, including Mr. Wade.
Joe, in camera means in private, so like in chambers. So they say that they willing to discuss it behind the scenes about with the judge, but they not willing to like talk about it on record on camera.
Different appropriate question.
Okay.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified
Well,
that he has no personal knowledge.
Unless it's for impeachment at this point, but Mr. Sada, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to
Okay.
do. And if Your Honor says
sure.
I can't, then I'm finished.
And
If-
I think that this was another aspect of what came up before, which is in my mind, even confirming the existence of the information goes into privileged communications.
Right, like
whether
you,
he
it's like
does
you
or
saying
does
like,
not
yes, I have information
possess
that
information
says
if it
that
came from that relationship.
like, come
that's
on,
part of
now.
the privilege as well. So if
That's
I make
saying
that
yes.
clear,
I
then,
like yes.
then
So you're
it's
sustaining
told
what
me
the
that.
objection would be.
That's right. It'd be sustained on privilege. to
And
that
of course,
question.
all the questions that we're
Preserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly.
Yeah, I'm sorry, y'all. This is why court ain't sexy. You know what I'm saying? Because like you get so caught up in rule challenges and objections, and they're like, this shit just moves so slow. And then yesterday, that's all. Like yesterday morning, that's all they argued with this nigga about was privilege or not.
So I guess my question to the court before I sit down is if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law he provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified.
That would mean that
Mr. Sadat, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one
argument.
I gave you,
The Coca-Cola one?
the 1935 case.
The Atlanta Bottling Company? I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court, but we can flush that out in our research.
I appreciate it. Thank you.
Okay. Mr. Stockton.
No questions, Judge.
Mr. Durham.
No questions, Your Honor.
Mr. McDougald.
No questions, Your Honor.
Mr. Rice.
Damn. I'm ready for this nigga to be done. I'm ready for it. He already just kind of opened up a whole nother can of worms in this in-camera
Mr.
hearing.
Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel.
Now they're about to ask him
on or
about
December 27th of 2021,
discrepancies and
correct?
inconsistencies in the interrogatories.
And you were also
Which
counsel
again,
on him for him when the amended interrogatories
ain't got
were
shit to
served
do
on
with
May
their
30th of
relationship.
2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can
Come on,
authenticate
nigga.
my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other
He
types
don't
of law
act
as
like
well.
it. I'll tell you that much.
That's correct.
He don't
And
act
are you
like it.
aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
Wait, what?
If you say so, yes, sir. Go ahead.
See that's still
Judge, I
around
would
here.
ask the court to take judicial notice of that.
Adultery
For what relevance?
is
Judge, I think
a
it does
crime?
go directly to the crime fraud exception. Because if
Let me know, Georgia
before we
people.
draw
Let me
objection,
know.
because
Is
if
it
Mr.
illegal to
Wade
cheat on
was
your wife?
providing
Is it a misdemeanor to cheat on your wife?
information to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime.
That's crazy.
It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let
we have
me pause you
three-
there. Isn't adultery as a statute just on its face been found unconstitutional? You
It
can't
is.
actually charge anyone with adultery anymore.
It is still current in the
Then it
state of
can't be a
Georgia.
crime.
It is still a current charge.
Let's
in the
move on to
state
that
of
next argument.
Additionally, Judge,
He done.
with regard to the interrogatories,
Judge,
there were
tired of
three
these
different sets of
fools.
interrogatories that were filed that came into evidence yesterday.
Bro, when the judge
21,
is straight telling you
May
that
of
your argument,
23,
let's
December
move past
of
that. Let's move
23,
past that.
that
Like, y'all not
contain
winning on that.
false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
You knew he was gonna have questions.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long
See, that
day.
said, nah, he reaching like that's what I was about to say. That
When
gotta
did
be
you
unconstitutional.
sign your engagement letter
He gonna get at him.
with-
Watch.
Mr. Wade to represent him in divorce proceedings?
Shit might get a little exciting right here, y'all. We're gonna see. Nah, no, it ain't. Look at this nigga.
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I haven't. I think
Hey, I'm still
there
right
is
here,
a
y'all. I just gotta
contract,
handle some business
but
real quick.
Right now, it'll be speculation.
Right now, sitting here,
Mhm.
you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had.
Shout
an
out to
engagement
Midas
letter
Touch.
to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open, when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I'm going to object to the relevance of this line of questioning. There has been no dispute from either the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
No, I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
So
okay.
We'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented
Again,
Mr. Wade.
No argument
I
about
signed-
fraud or anything else. It's just whether or not he was actually Mr. Wade's attorney. Come on now.
With the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
I told y'all he was gonna
It
get
was
at
a
him.
work environment, yes.
A work environment.
This
when
is at
you-
least
where
what
you
real
and him
opposition
would, meet and
attorney
talk
cross-ex
literally
look like.
every day, correct?
This ain't even
Not
opposition.
every day, no.
This
Well,
is they
almost every day. When you
Not almost every day.
They
I
witness.
stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So well, just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether
he
you
out
as
here
an
looking
attorney
bad out
got a
here.
single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to object to ask and answer.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. And I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship did exist. Well, at some
Reaching.
point.
I was just
Reaching.
laying the foundation to the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It was from a overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm.
Y'all see
and
his
you were
face?
doing him as essentially a favor.
Like it looked
as
like
a
it
friend
hurt.
and as a law partner, correct?
Like, that boy's stiff.
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
They literally went
Yes.
and found
And in a small
ex-friends to
firm,
try to
and
bash
I
these
know,
people.
'cause
This is
I'm
crazy.
in a small firm. People will sit around the office and talk about their
The
social
Trump
life and what they're
administration
doing,
knows
correct?
no bounds. Or excuse me, the Trump private citizens and attorneys
Correct.
know no bounds.
If that happens in your small firm, yes, yes.
Well, does it happen or did it happen in your small firm?
Yeah, I'm gonna, the witness has been asked very specific questions about conversation about socialization, and we've gone all through it, so I think this is asked and answered.
All right. I'll let him answer this one question. Overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
I assume we,
Understand where he going and answer already. You
Not
should
yet,
al-
but it might.
You should
I
already know.
assumed, yes, we've talked about sports. We talked about,
But we rarely discussed our romantic lives.
sports a whole lot.
You talked about life and about what was going on in your life and what was going on in his life, right? Right?
Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors.
See, this
for
and
them,
this is what I
correct?
was saying was finesse, right? He got a little like he got a little bit of finesse.
Yeah. All right. Sustain. Next question, Mr. Gillen.
Now, in that capacity, didn't you
She
have
caught on into
discussions
his
with
ass, but it's a
Mr.
little
Wade about
finesse.
what was going on
It's a little
in his
finesse.
social life that had nothing to do with him asking you legal advice?
Objection, to be more specific.
I think he's just asked whether he socializes outside of legal advice. So I think he can answer that question.
Bro, you should know where
I
he
did
going with
answer.
this. Did y'all
the
ever talk
question.
about
I
Fani?
said we talked about sports a lot.
And I'm asking, sports is one thing, the social life. Did you talk about each other's social life?
No.
Like Mr. Wade and who he was
I
dating?
don't recall. I don't recall.
So that'll be sustained on privilege.
Your Honor, and just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out illegal
But the judge sees
advice,
what you
not
already
talking
trying.
about
He already
something
see
that
what
might
you're
be
trying to do.
personal or confidential, and that's
He already see what
that's
you're
a
trying to do,
distinction
though.
that I would draw.
I think that's a accurate legal point. However, I think the witness has already been questioned and testified on this point.
Thank
So
you.
next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
Mm.
I'm assuming we,
Objection, he's asking about interrogatory responses, preparation of the case in the divorce case, and that's all.
Mr. Gill?
Well, I don't think it's attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them? And did he do that
Yesterday-
in concert with his
Yesterday,
client?
this same
With
attorney
another-
tried to get Nathan Wade caught up on the same interrogatories question, because to catch y'all up on the interrogatories question, during Nathan Wade's divorce, it was questions specifically about if he was like entertaining women or if he had intercourse with any other women from the time that he got married to the present. And at first he said 0, and then he later changed it to privileged, right? So they're trying to call into question why he changed it, and was it accurate when he initially said 0, like he didn't entertain any women and he hadn't had sexual intercourse. So he's trying to push up on his attorney with the same shit.
All the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's the follow-up question to that is going to be incorporating knowledge learned during communication. So I'll
Oh,
sustain
no,
my
I'm not going to have
privilege.
a follow-up question. I just want to know whether, is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay, in which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had.
So really, they trying to set up for closing arguments, right? Because where they are is they're trying to impeach Nathan Wade by lying on the interrogatories, right? And the assumption is that they lied on the interrogatories. And then closing arguments, they're going to impeach his attorney with the same shit, because it's like you filed it with him, you looked over it as his attorney. So if he lied, if it was a lie on that paper, you was a part of that lie.
And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
Okay, so what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it, so the whole matter is covered under privilege.
One comment on that.
I was just about to point this out. Like, they've been talking about privilege this whole time, and only because he ran his mouth in the first place about privileged information. He brought this on himself.
2021. And questions about
He brought this on himself,
2019, all objected to, the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What
Okay.
did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case,
Peaches.
the divorce case.
Peaches, yeah, nah, he no longer represents him right now. He doesn't represent him right now.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021.
And y'all know the only reason this is a part of the conversation is because that's allegedly what he told Ashley Merchant.
Wade, but Mr. Wade would want to
defense
insist
counsel
on responding to interrogatories which were contrary to the information that Mr. Bradley would have. Then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that. Therefore,
Hello, Popak. How are you?
Oh shit! Hold on.
Can't hear you.
So
I think that you are.
I'm not trying to be stealing their whole stream, so we're gonna cut that off there. We're gonna cut that off there until we get to, you know what I'm saying, back to it. I think what they about to speak on is Donald Trump. Hold on, let me pause that. So I guess Trump, let's see how much they just charged. They hit Trump over the head with. We could take a little quick break from that. They weren't even getting into too much anyway, but Trump in his fraud case. Let's find out. All right, let's find out what's going on in the Trump and Fine case. All right, CNBC: Trump fined more than $350 million in New York business fraud case. I thought they was gonna hit him with 5, so it looked like he kind of got off a little bit, got a little dub on that. But fined $350 million. The New York Attorney General Letitia James accused Trump and his companies of fraudulently inflating the assets. Let's look into it. Judge Engeron hit him with $350 million. And okay, this is what I really cared about. This is what was more interesting. They about to hit him with the so-called death penalty, as it's called in business. All right, Manhattan Supreme Trump is banned. Here we go. Manhattan Supreme Court Judge Arthur Engeron also barred Trump from serving as an officer or director of any New York corporation or other legal entity in the state for 3 years. So that means that the nigga can't be no type of CEO. He can't be CEO of shit in New York. All right. And Trump is banned for 3 years from applying for loans from any financial institution chartered by or registered with New York Financial Services. So he can't get no checks, no loans from nowhere in New York. All right. So I guess that's what they breaking down for the time being. We gonna try to see when we get back to the trial. But yeah, right now they stuck on this Trump shit. This I don't care so much about. Is it interesting? Yeah, you feel me? 350 million, that's a lot. That's gonna hurt Trump. Especially he got 80 million to come up off of with E. Jean Carroll, which Trump not only lost a civil rape case against E. Jean Carroll, he lost a defamation case against E. Jean Carroll, so he got to come up off 80-something million, all right, for allegedly raping this woman and then lying or talking down on her, defaming her in public after he did that. What I think is extremely interesting though is the double standard that we see, even with the black people trying to tear down Fani Willis, even with the black folk that's like, you know, Fani shouldn't have been doing this, he shouldn't have been doing that. This nigga has just been found. He found liable of rape, liable of defamation. Just got fined $350 million. He got the Georgia case. He got the DC case. He got the Florida case. He got the Manhattan case, and he's still the front runner for president. We sitting here having to have these hearings on Fani Willis, and you got niggas telling Fani, well, Fani, you should have been moving different. You know what I'm saying? You in a better position. You can't be moving how you typically moving. But how is Trump? How is Trump able to still be the front runner? To still be the front runner for president? And we calling into question Fani Willis having a relationship? This nigga has a huge following of people. There's no other Republican candidate that's even close. Statistically, Donald Trump is the candidate, period. Statistically, nobody else can get it at this point. And we talking about Fani Willis and what she should be doing and how she should be moving, how she should have been smarter about. Y'all got me fucked up. So we ignore because total Trump about to have to come off of about $600 million. $600 million from campaigning. $600 million from acting like he want to be president and shit. But we sitting here watching people talk bad about what Fani Willis got going on. What Fani Willis got set up, man, hit the like button. This shit is crazy. The double standard is crazy. And I think what make the double standard even worse is that, let me see if I can pull it up. Fani Willis, in her filing against this whole shit, displayed the court precedent. This which I gotta understand above everything else. The court precedent has already been set. Let me see if I can dig it up real quick. Let me see if I can dig up the filing, Fani's filing from a couple weeks ago. I think it's right here. She already showed. Yeah, here we go. I'm about to show y'all where Fani already killed this argument about, she was irresponsible because she shouldn't have been having a relationship in the first place. Hold on, what am I? It's messing up. What is it doing all the way over there? I'm about to show y'all straight up how the courts then already decided that this really ain't got shit to do with shit. Let me see if this is the right one. Hold on. Yeah, this is it. Hold on, y'all. Going through these filings is difficult. Let's see. And then we're gonna check and see if we back on the joint. Come on, where it said it was like 1B. 1B. That's when she was talking about. I'm pulling up the filing to show like literally court precedent that's like, nah, people can have relationships and that shouldn't have anything to do. That shouldn't have anything to do with them, with how they handle the cases. The precedent is there. Hold on. Damn, I can't find it. It's in there though. I'm gonna hit y'all with it when I find it. Let's check back and see. Nah, we still waiting on it. But I'm gonna find it, y'all. But anyway, with the courts already saying that we should expect attorneys to be able to have relationships amongst each other, but still be able to like go about our job effectively and efficiently. Like the court, like Georgia court specifically already decided it. That it's even allowed to have literally one candidate or one spouse on the defense and then one spouse as the plaintiff and cause no conflicts. No conflicts. So As much as we make a big deal about this whole she had a relationship with him part, that's not what they gonna get her, what they trying to get her on. They're trying to get her on the financial gain. Did she get any financial benefit by putting him in that position? Because even the judge said that is the only disqualifying factor of this whole case. Now, they are trying to say that Nathan Wade and Fani Willis really in this pleading actually lied about when their relationship started, which would then, which would then be illegal because it'll be perjury. But outside of that, the main thing that they could use to disqualify her is this question of whether or not she financially benefited, and we ain't seen that. We ain't found that. They the small attempts that they used to get towards was that they failed, and I think the most damning piece of evidence against the defense and that accusation specifically is the nigga was doing work and wasn't even getting paid. The nigga was doing work and wasn't even getting paid. So it's no way that you could tell me that she was benefiting from him financially and this nigga working for free. Pisha said, I thought it was that she spent state funds on their romantic trips. That's the thing. That's all the shit that you hear in the media. That's the conversation you hear in the media. The reality though is that the trips, and she talked about this a lot yesterday, the trips that they took, he put on his credit card and she paid him back in cash. There was literally there's no proof that there was any money that was specifically given or heightened, or he was giving more money for any reason to take her on trips. That's just the media spin. That's the bullshit that they spread. That's not the reality. There was no, any money that he would get for any work that he do, that's his bread. And what he do with his bread is his fucking business. But the reason why they say that they was using state funds on those romantic trips is because they was trying to say that they was going on lavish, huge, $15,000 trips, and that wasn't even true. The nigga was going on Carnival cruises with his mama and Fani Willis, with his sisters and Fani Willis. They wasn't even, you know what I'm saying, there wasn't no Virgin and no super big shit. Nah, it was the cruise that everybody be on. So, again, we get all this controversy. We get all this controversy over this conversation about them being together. And there's nothing really there. And we seeing that there's nothing really there just based on the way that this hearing is going. Peaches said, but what is wrong with him paying for dinners and trips? Agreed, nothing. Nothing. The only reason it's being made a big deal is because it's Donald Trump and because it's a black woman as a district attorney. White men do this shit all the time. White men date within they legal circles. You feel me? Like they date like back and forth. Like we know that this exists. That's why this whole shit is crazy. But because it's a black woman, that's why everybody's so willing to tear her down and say it's her fault. What the thing that white men have done consistently, historically, sleep with their colleagues, develop romantic, relationships, also networking. White men network. Hey, I know a guy. Hey, I got a frat buddy of mine. Somebody I went to school with. Hey, my cousin. They always putting each other on. It's called networking. So now that Nathan Wade is like, yo, I know about some opportunities with the district attorney's office. You know what I'm saying? If you wanna hop on that. Now that's deemed as unethical. And I feel like that's not the conversation people having. The two things that happen routinely in legal fields, dating and networking, is now being put on display as something that was unethical. As something like she should have known better. What? Show me this standard used on in any other legal circumstance. Especially when the questions have already been brought up in court and can't nobody that's saying she should have known better cite the precedent that says that we should assume, that's the court. The court should assume that attorneys can have their relationships and it not impact how they do their jobs. And that's legal precedent in Georgia. But she should have known better. That's crazy to me. The only logic that I could come, the only understanding I could come to as why that accusation and that standard would even exist right now is because it's a black woman. And it's because it's an attempt to protect one of the most fraudulent, dangerous politicians we've ever had in Donald Trump. Let me see. Man, we already knew he was gonna get hit over the head. We need to go ahead, get back to this. Let me see. I'm gonna see if somebody else, if I can pull it up somewhere else. I appreciate y'all rocking with me, man. Y'all been rocking with me for down there 2.5 hours. You know what? Actually, I'm probably just gonna make some content about it. I'm gonna leave it right there. And check in with y'all in a little bit, just cause shit. We back. All right. And this nigga still on the stand. Goddamn. I was hoping he's gonna be off by now, but let's bring back the audio.
Let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity, but y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022, prior to you leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during
This
the
nigga
time
body
before
language
y'all bought
changed.
some
He must have went to the
bodybuilding
restroom
together.
over the time they
Yes,
was talking about
correct.
that other shit.
And it made things simpler. For whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23. What's the
Made
hourly
premium.
rate
Made
that
premium.
you're being
Appreciate the
compensated?
love, family. Appreciate the love.
That was
23 is the I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
150 an hour.
150 an hour? All right. So the 150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
Now this is the state. This is Fani, Willis, and them questioning.
It seems
this
to be
nigga.
the
And it's like,
same.
I don't know what y'all gonna get from this.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you
Oh no, the amount was 65 an hour.
$65 an hour?
Mhm.
That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right. Was that a government rate that you were willing to accept at that time?
Yes, that is correct.
All right. And so the $60 you're getting for that contract, again, that split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were
Minus
asked-
expenses and stuff like that, but yes.
Exactly. That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So questions about Mr. Wade, I think the phrasing, and I object to it, but I think you might recall the question, Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
All right. So we're talking then about a split among the three of you of about $20 a piece, right? For that particular contract?
For this one, yes,
All right. What about 24? Have you got 24 there? I'm sorry, 25. Have you got that in front of you?
I do.
What's the hourly rate on that one?
It's 150.
150 on that one too? All right. And the same sharing went through the business, the way you handled that contract as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes,
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
that is correct.
2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances, but you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time?
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time?
Yes, we were friends at that time, yes.
All right. You are no longer
It's
business
like pulling
partners.
teeth with this nigga.
That is correct.
You are no longer friends.
Did it hurt?
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I would consider,
His feelings hurt.
Goes to potential bias. Ms. Cross.
would I consider myself a friend of Mr. Wade? I would.
Bro, how? How, nigga? You gossiping about this nigga to Miss
You
Merchant.
asked questions, Mr. Bradley, about the circumstances under
Come
which you
on,
left
bro.
the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained
Bro,
the same
listen.
as far as other employees, Mr. Wade,
Who
Mr.
need
Campbell,
enemies?
as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. Do you recall answering questions as though you left due to a disagreement? Yes?
Yes,
And
You're
that
getting
disagreement was that
scrunched
there
up
was
again.
an allegation of sexual made against you, correct?
that is incorrect.
There was not an
Whoa.
allegation that you that you sexually assaulted one of the employees in the firm.
Whoa.
That is incorrect, but
Whoa. What happened, sir?
yes, yes,
Yes, there was an allegation that you sexually assaulted a member of the
Yo.
firm, correct?
yes, that was an allegation. Yes,
And as a result of that allegation, you left.
I did.
You were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact,
That's
the
why he
employee
was
involved
gossiping about
remained
that
with the
nigga.
firm, correct?
I'm not certain of that. They did
That's why he was-
leave the building, of course.
Oh, let me,
And I don't
let me
know.
take some notes, man.
Some of the
I got
employees
some
did
content
leave.
I'm gonna put out later, definitely about this shit. Cause now it makes
Mr. Bradley, in
sense.
fact, received that in
Brother
employee
Rob in the
$20,000,
building, man. What's
correct?
good with you?
That
bro?
is
Appreciate you for being here.
That is incorrect as far as what was. No,
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
there was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you
I
suffered?
never gave any money. I left the money in the escrow account. What happened to that money? I can't, I don't know what happened to it.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
There was no purpose.
They was on
You
his
just
head.
left the money in the escrow account?
They on his head. Oh man,
Yes.
this nigga did not want to
If
be
there's
here.
no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you,
I mean,
why
we're not
was it
laughing
that
at
you
sexual
brought to
assault,
my
y'all. I'm
attention?
not laughing
Why'd
at
you
sexual assault.
respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
Look, y'all coming out the woodworks now. Look.
I didn't hand any money. It was money from my escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go
To the employee.
to that employee?
Oh, bro. Yeah, it's.
Was there
Yikes.
one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
It's one incident.
There were not two.
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients?
The
of your
defense
firm?
brought two
No.
ex-friends.
Never.
Who's Anna Rodriguez?
Woo! Hit him with a name.
I don't even know that name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
You don't.
Never met her.
I do not recall the name Anna Rodriguez.
Where you gonna go with the state?
From Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this line of testimony.
All right, Ms. Cross.
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in
Okay.
involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
All right. At some point, though.
I'm not
And well-
going to go much further.
Okay.
Judge, if this is allowed to continue in this way, and it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not?
Wow.
Don't do that.
Mr. Chover.
Sit on it. I think
Wow.
you've already done that.
Your Honor, I'm asking in all seriousness
Will he
that
be
privilege,
excused from
although
his privilege?
Based on the answer right now, I think now we've opened up a whole area. What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
Ooh.
Okay. Mr. Sadow.
Ooh. The state may have just fucked up.
You were accused by Mr. Wade of misconduct.
Here they
in the
go.
course of your representation of Mr. Wade, correct?
Here they go. Finally,
I was not accused by Mr. Wade, no.
we
Who
here.
accused you? Did Mr. Wade not, based on the questions were just asked, did Mr. Wade not bring to your attention the sexual assault allegations?
They shouldn't have brought that shit up. Miscue by the state for sure.
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not, I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
I was saying the
I'm
same
not sure
thing,
that
brother
that's
Rob.
accurate. He was accused by Mr. Wade, his client.
Accused by
Do you
Mr.
mind if
Wade.
I speak? I allowed you to speak.
Mr. Sadow.
Mr. Wade accused this gentleman.
They feel like
of
they got something now,
misconduct in
boy.
the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Understood. So what is the
Did
question
the
you're
state
My question
just
I'm going to ask you
void
now is,
attorney-client
tell us what
privilege?
Mr. Wade told you about when he began his relationship with Ms.
Okay.
Willis.
All right. So where I think we are with this is that Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege.
Fucked
When
up.
asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. But is there anything else, though, that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of it.
Right. So this is where he fucked up. When he was first asked about understanding how why he no longer represented, like when he said why he no longer is representing Mr. Wade, he said he didn't want to get into that because it got into issues of attorney-client privilege. When he was talking about him being accused, he turned around and explained what he was accused of and why he left and why he no longer represented Mr. Wade. So the thing that he said that he didn't want to say to the defense, he turned around and said it to the state. The issue that creates for the judge is that now what he heard that was initially considered attorney-client privilege, the judge is saying that doesn't sound like something that would be protected under attorney-client privilege. So therefore, I'm reassessing every instance in which he called for attorney-client privilege, because now I'm calling into question his understanding of attorney-client privilege. So now all them questions about, what he knew about them being together and all that type of shit, they're now more plausible in terms of what the judge thinks about what is contained in attorney-client privilege. Yeah, they fucked up.
Report back if upon order of the court, but otherwise, is there anything further the parties need from him today?
Yeah, but I wanted to get those sort of.
I know there's other housekeeping things and things we need to do.
And based on his testimony, you do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have another witness.
I do.
Okay. All right. In that instance, okay, Mr. Bradley, you can step down, sir. However, I'm giving you the order to stay in touch with your attorney, and then we're gonna have to find a time to meet again and go into an in-camera session. Do you understand, sir?
I do.
Okay.
They just
All right,
fucked
thank
up
you,
this
sir. You
nigga.
can step down.
If his reputation
Mr. Chopper, do you have a
already
card
wasn't
for me?
fucked up, they just made it even worse.
Okay.
At least I hope I do.
Oh boy, that was sloppy. That man, oh man. I mean, listen, ain't none of
I'm the
us.
worst lawyer on earth. I usually just tag bus stations with my
You can
number.
write down your contact information for us.
I would.
All right. Ms. Merchant, do you have any further witnesses?
See, hey, look, he just said I'm the worst
Okay.
attorney on earth. Yes, nigga,
Um,
you're getting that label after the day.
On the issue of the Bill Solinsky, 1006 first 611, we're not going to call him. We think the chart, the foundation of the source of the chart is sufficiently in evidence, and we can just use the chart during argument under a 611 demonstrative.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor, given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the
Now we
record in
have
advance of
what you
arguments
call
instead
a
of-
wild card, people.
I don't know when we're going to be able to have that scheduled.
Man, I was thinking this shit was gonna be a couple days
I
and
think
be
this would be
through.
defense exhibit 28.
This shit about to be drug out.
But let me
I
go down
thought
the
we-
order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Sadow?
Your Honor, we are in the process, if the court will allow us, to obtain certain phone records.
Told you.
and
I told y'all that
records
yesterday.
that open For the introduction of those phone records. We have been
I
in
told-
draft say draft, we have them informally, we do not have certification yet.
They
They
trying to
deal
get
with-
them on
So
perjury.
remember, I asked Mr. Wade about certain activity down in Hayfield during the time period, and it deals with that specific time period. So we're talking about
Yo, this shit gonna last as long as a trial.
2021.
They trying to get
November
phone
1st.
records. They trying to get flight
And
records.
is it your intention that you would want to introduce these solely as an exhibit, or you think that this should reopen and bring us back for an entirely new evidentiary day with
I
witnesses?
told y'all that yesterday.
We want to, if what we believe is there, based on our preliminary research, is there, we'd like to reopen and be able to introduce records and someone to explain what they need.
I told
So
you.
that's it.
The
They was
state certainly-
fishing.
I'm sorry, were you finished, Mr. Segal?
I believe so.
Thank you.
All right.
The state would certainly have an objection to that. This hearing has been set. We haven't seen the records. So I don't know if I have any objection to what they are. But the day has been set for quite a while, and we object to leaving the evidence open for any purpose.
Okay. And Mr. Sadao, when did you first go about trying to obtain these records?
After yesterday.
I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship, but put parameters on the timing. I sent subpoenas out in response to that. So that was February 9th. Problem is Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting. I wanted to remind the court, waiting for those records to be submitted in camera.
Yes.
And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticated?
Yo, they are reaching self-authenticated.
If counsel are able to,
I told y'all they just
provide
digging to
those,
try to find something to say, well,
obviously
you lied
serve those
about
on
this. That's
opposing
perjury.
counsel, and then before sending them over to us, let us know whether they would be tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format. But the exhibits themselves, I'm willing to have come into the part of the record, but there will be a cutoff point very soon, as soon as we schedule argument. All right. Any other evidence, Mr. Sadao, then? So that would be cell records. Mr. Stockton, any evidence? All right. Mr. Durham, if you're still with us.
No, Your Honor.
All right. Mr. McDougald.
Copies I mentioned to Your Honor yesterday, Your Honor.
Okay. And why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28, I just said, was Mr. Gillen's
Right.
demonstrative, just so I'm keeping it straight.
All right, so
I
we just
previously
got
provided these to
evidence
the
being submitted into the court.
29 would be a certified copy of county.
Nothing exciting. This is all process oriented shit. Nothing crazy, but we damn near approaching the 3-hour mark. A little explosive at the end there. I say that old boy is now what I would call a wild card, because if he has any solid evidence about him and Fani, Wade and Willis confirming any romantic relationship before 2022, then I can see issues of perjury. But again, I don't see Fani Willis being that dumb. Like, that's just that would be stupid. Like, to have documented evidence of y'all dating before 2021 or 2022, and then just lie to the court like that. I'm like, I saw who Fani Willis' daddy is. She's the district attorney. Like, I just expect her to have more sense than that. So, like, out of everything they could have said, lying about when they started dating, I don't even really see how, like, they would need to lie about that in order to, win what they're trying to win. The state has one more witness. We're gonna see who that witness is a little bit later, and if it's somebody worth us sitting down and looking at, then we're gonna do that. But outside of that, man, I'm gonna go ahead and wrap this one up. It got more exciting at the end, but old boy is a liability. I'm telling you, like, you cannot, if y'all ain't take nothing away from this hearing, watch who you fuck with, watch who you around. Like, the fact that this nigga was even gossiping about Ashley Merchant, gossiping to Ashley Merchant about Nathan Wade, it's like, my nigga, yeah, like, y'all on other shit. So But with that being said, y'all stay tuned for the content. Follow me on Instagram at The Political Plug. On TikTok at The Political Plug. I'm gonna have some little breakdown and analysis. Me and Toya should be going live tonight. I gotta hit her up or this evening. It'll probably be tonight for the rest of y'all. Y'all know we over on the West Coast. We should be going live tonight. We had interesting conversations to dig into. If not tonight, Saturday. But we gonna figure it out. But appreciate y'all joining me for this long. We was really getting it in. Right, no one talking about when the sex started. You funny, Miss Mel. But yeah, appreciate y'all for joining me for this long. I'll be back soon. If it get exciting again, I'll be back. If not, I mean, we just gonna get the content out, breaking this shit down. But outside of that, y'all be easy. Enjoy the rest of y'all day. I'll holla.